General exceptions in Pakistan Penal Code. Introduction. In Pakistan, Pakistan Penal Code is the major criminal law which defines substantive offenses and prescribes their respective punishments. This code also describes some specific circumstances in which crimes are though committed, yet offenders are exempted from punishments. In such circumstances, it is not intention or guilty mind which constitutes crimes, but it is external force, which instigates mind to commit crimes. Definition. In criminal law, a settled principle is that no innocent should be punished even if 1,000 criminals escape. Here, explanation is that it is not just to punish someone who is controlled by a criminal as a puppet to do an illegal act. Likewise, there are certain circumstances in which an apparent offender is exempted from major punishment or is entitled to just minor punishment. Such circumstances have been termed as general exceptions in Pakistan Penal Code. General exceptions in the light of Pakistan Penal Code. In Pakistan Penal Code following are: general exceptions have been provided. I. Mistake. If an act is done by a person who is bound by law to do it or who, by reason of mistake of fact and not by reason of mistake of law, in good faith believes himself, herself to be bound by law to do it, such act is not considered an offense. Judicial acts. Under Pakistan Penal Code, following general exceptions have been provided in respect of judicial acts. A. Act of judge. An act is not an offense which is done by a judge when he/she acts judicially in exercise of any power which is given to him, her by law, or which he/she believes in good faith to be given to him, her by law. B. Act done. Pursuant to judgment or order of court, an act is not an offense when it is done in pursuance of judgment or order of a court of justice, or which is warranted by judgment or order of a court of justice while such judgment or order remains in force. Trick. Acts justified by law. An act is not an offense when it is done by any person who is justified by law in doing it, or who, by reason of a mistake of fact and not by reason of a mistake of law, believes in good faith himself, herself, to be justified in doing it. If. Accident. An act is not an offense which is done by accident or misfortune, and which is done without any criminal intention or knowledge in doing of a lawful act in a lawful manner by lawful means and with proper care and caution. V. Necessity. An act is not an offense which is though done with the knowledge that it is likely to cause harm, yet it is done. It is done without any criminal intention to cause harm, and in good faith for purpose of preventing or avoiding other harm, to person or property. Of infancy, an act is not an offense which is done by a child under 7 years of age. Vic. Child's immaturity. An act is not an offense which is done by a child who is above 7 years of age and under 12 years of age, and who has not attained sufficient maturity of understanding to judge nature and consequences of his/her conduct on that occasion. V. Insanity. An act is not an offense which is done by a person who, at time of doing it, by reason of unsoundness of mind, is incapable of knowing nature of act, or is incapable of knowing that he is doing what is either wrong or contrary to law. Fiqh. Intoxication. Under Pakistan Penal Code, following general exceptions have been provided in respect of intoxication. When intoxicated person is incapable of judgment. An act is not an offense which is done by a person who, at time of doing it, is, by reason of intoxication, is incapable of knowing nature of act or is incapable of knowing that he is doing what is either wrong or contrary to law. B. When intoxicated person does an offense which requires particular intent or knowledge. In cases where an act done is not an offense unless done with a particular knowledge or intent, a person who does tea